There is a provision in the tax bill before Congress that substantially affects the practice of family law. And if it passes, and it very well could, it's going to make a major difference, not so much to the way we practice, but to our clients and to their detriment. And that's whatever side you're on. In the House version of the tax bill that's currently being debated by Congress is a provision, it's Section 1309 of what's called the Tax Cuts and Jobs Bill of 2017. That section would eliminate the deductibility of alimony, or what we call maintenance, in Wisconsin. And that's very, very significant. The difference between deductibility and not deductibility can be seen by simply taking your favorite local up-to-date Mac Davis program and running a few numbers. And I did it on behalf of a client recently just to see what the effect would be. And the income was more in your normal case, but if you take $250,000, $300,000 for the payor, and I think I took $25,000 for the payee or something, and I ran it both ways. What's the difference if the payments are deductible, and what is the effect if the payments are not deductible? And the effect at those income levels came out to be a difference of $500 per month net per party. So in other words, it's $1,000 a month to the couple, or $12,000 a year after taxes, which would either be additional money that they could each spend, or would be money that would go to the U.S. government to help reduce the deficit. And please don't count on any money going to the U.S. government to reduce the deficit of actually reducing the deficit. As I understand, the political reasons for this is that the current tax bill basically reduces tax rates overall, and in doing so substantially blows up the deficit. There are some members of Congress who profess that they are, quote, deficit hawks, end quote. That's a deficit hawk. God forbid I should ever see a deficit dove, but members of Congress who don't believe that they should substantially run up the deficit and leave this huge bill for our children and grandchildren. There are some of us taxpayers, some of us parents, some of us grandparents who don't want to leave that type of world to our children and grandchildren. But you don't get elected to Congress or reelected because you reduce the deficit. You get elected or reelected because you tell people, I reduced your taxes. And moreover, you don't want to be attacked by your opponent in the next election for voting against tax cuts. Everybody loves tax cuts, and it's a great political tool. The actual effect in terms of society, the economy, and what it does to our future, well, that's something else. And as I understand what's happening is that in order to mitigate the effect on the deficit of these tax cuts in this bill before Congress, they got to look for some areas where they will be essentially increasing revenue and therefore reducing the horrendous effects of this bill. And one of the areas is to eliminate the deductibility of alimony or maintenance. And the reason that would be effective in terms of how Congress is concerned is there is no effective lobbying group of divorced couples that would go to Congress, lobby their legislatures, and tell them, hey, please don't do this. This is very important to us. Other areas that have constituents that would lobby Congress, such as the NRA, for example, are amazingly successful because they're organized, they're intense, and they're well-funded. None of that exists in this area. The American Academy of Matrimonial Lawyers has taken a position and are alerting legislatures opposing this bill, but the ABA is not equipped to do so. It takes a lot to get the ABA to move. I compare it to trying to steer an aircraft carrier. It isn't going to happen real quickly, and it's not going to happen on a dime. It's hard to get it to move at all. And the timing of this, because Congress will be voting in the next couple of weeks, just isn't going to happen. The AML has virtually zero lobbying effectiveness in Washington. They're not a particularly well-known group. They're not particularly well-funded. They don't give money to politicians. The ABA is a little more effective, but they're not going to take a position on it because the next meeting isn't until February of the Board of Governors, and it's way too late to do any good here. And even so, I doubt they're an effective enough lobbying group that it's going to make any real differences. So essentially, there's nobody to speak for divorcing couples in terms of the fact that we're using their money to help offset the additional deficits being created by this bill to be passed down to our children and grandchildren. And don't think this can't happen. I started practicing family law in late 1984. Boy, it seems like a long time ago. I was 6 years old at the time, if you're interested. But in any event, when I started practicing, I was told ignore the current law, because January 1, 1985 is when DETRA, otherwise known as the Divorce Tax Reform Act, I don't know what the E was, but the Divorce Tax Reform Act would come into effect. And so learn that law, not the previous law that was currently in effect then. Well, the current law prior to DETRA made it easy to deduct family support. And it was very, very common in cases where there were minor children and a spousal support obligation to combine them in one payment and call it family support. DETRA did not eliminate that. What DETRA did is made it very, very difficult to do family support on a deductible basis by creating a number of hurdles for it. We still do family support on occasion, but it's become rare to do it, and it's far more common to divide support payments between maintenance and child support, which has two detrimental effects. One is it increases the likelihood of litigation in the future because not only under family support, you just have one payment, which could have a substantial change. If you do it under different scenarios, one child support, one maintenance, you've doubled the probability or possibility of future litigation in each area as children age out, income goes up or down, or whatever other reason you'd want to go back on either issue. And the second one is as follows. There is a philosophy that's supposed to be in play that we use our tax laws, we being Americans and through our legislators, to effectuate what we believe to be societally beneficial matters. For example, we want to encourage people to give money to charities, so we make charitable deductions deductible, charitable contributions rather deductible. Or another example, we favor home ownership in this country, and therefore mortgage payments and property payments are deductible on a federal level. Whether you agree, it's hard to disagree with the societally beneficial nature of charitable deductions, but whether or not you agree with home ownership, these are societal issues that have been decided that are important to our culture, and therefore we use our tax code to promote it and to make it easier to do by making charitable deductions deductible, interest on mortgages deductible, property taxes deductible, both to effectuate and promote what we believe to be something that's societally beneficial. Which brings up the issue is, why wasn't in 1984 paying support to children societally beneficial? Why wasn't it viewed back then as something, hey, don't mess with this. This is a good thing if we can combine these payments into one, because A, it would reduce the chance of future litigation, which would benefit children. Children are harmed if the parents rather are fighting. And number two, it would increase the amount of support that could be paid for these children by using our tax code to make it deductible to the payor, taxable to the payee, and shift some of the tax burden. Well, it was the same answer in 1984 as it is in 2017. Children don't have an effective lobbying organization in Washington that's going to go to our congressmen, congresswomen, senators, and say, hey, don't do that. They listen to people that are contributors and that are effective lobbyers, and children don't have that in Washington. Similarly, today, people who are going through a divorce don't have effective lobbying organizations. They don't have PACs that are contributing money to people's campaigns. Is this the way democracy is supposed to work? Of course not. It's supposed to be that our legislators are doing what is in their constituents' best interests, but in real life, that's not, of course, what happens. Our legislators do what they think is going to help them get reelected. And as I said, they don't get reelected by running on, look how much I've reduced the deficit. They get reelected, or at least they think they do, by telling people, hey, I voted for a tax cut. Therefore, this could very well pass, and it could very much have a detrimental effect on the payment of support, because it helps convince guys and women now who are in the position of paying maintenance that these payment, in negotiating the length and the amount, it takes some of the sting out of it when it can be deductible, and it also increases the amount because even though we have far fewer tax brackets now than we did back in 1984, there's still some tax savings, as I mentioned earlier in the one case where I ran the numbers, that would utilize the tax code for what I believe to be a societally beneficial purpose, supporting families and supporting dependent spouses. So what can you do about it? It's real simple. Call your congressman, congresswoman, whatever it is. If you live in Wisconsin, call Senator Johnson, call Senator Baldwin, and tell them that this law hurts divorcing people. It causes problems in our divorce system in terms of encouraging support to be paid and encouraging the use of the tax code to give maximum benefits to people who are divorcing. Most people who are divorcing do not have sufficient income to support their families in the same manner and method in which they did before the divorce. The theory in maintenance that the standard of living enjoyed during the marriage is a factor is a nice theory. The reason it's only a factor and not a requirement is it just can't be done. And when you're dividing up income, absent the few people out there, as the late Judge Sheedy used to say, there are 3 couples in Milwaukee County who can afford a divorce, and I don't see any of them in court today. So unless it's one of those 3 couples, most people can't afford a divorce, and it's a matter of the degree of suffering financially that each party is going to have. Using the tax code to shift some of those payments from a higher tax person to a lower tax person helps eases some of that suffering and makes it a little easier for both of the parties in the future. So it's a scary situation. It's something that could very well happen, and there isn't a lot we can do for it except to lobby. Please call your legislator, your congressman, your senator, and ask them to vote against Section 1309 of the Tax Cut and Jobs Bill 2017.